Can a 16-year-old take a loan? Can a drunk person sell his house at midnight? Can a mentally unstable person sign a million-rupee deal? These questions are not just theory, they decide whether a contract is valid or completely useless in the eyes of law. This is episode number 4 of the Indian Contract Act series by NAVA Legal, and today we will learn one of the most fundamental pillars of contract law, capacity to contract. Every contract creates legal obligations. So the law wants only those people to enter into contracts who are capable of understanding consequences. Section 11 of the Indian Contract Act says a person is competent to contract if he is a major, of sound mind, and not disqualified by law. If any one of these three conditions is missing, the contract may collapse immediately. Let's start with minority. The age of majority in India is 18, but if a guardian is appointed for the minor's property, then the majority age becomes 21. A minor cannot be forced into legal liability. That is why a minor's contract is void from the very beginning. Imagine a 17-year-old boy walks into a showroom and buys a bike on EMI. He enjoys the bike for a month and then refuses to pay. The seller cannot sue him because legally, that boy never had capacity to contract. But law is not heartless. If a minor receives necessaries like food, school textbooks, or medical treatment, the supplier can recover the amount from the minor's property because humanity and welfare cannot be ignored. Now let's talk about soundness of mind. The law asks a very simple question. At the time of entering the agreement, was the person capable of understanding what he was doing and making a rational decision? A person suffering from mental disorder or someone who is heavily drunk, sedated, or unconscious at the moment of signing the agreement cannot be forced to follow that contract. For example, if a person suffering from Alzheimer's disease is tricked into selling his house, his family can challenge that agreement because he was not in a position to understand what he was signing. However, a person who has temporary mental illness but is perfectly normal on some days can enter into a valid contract when his mind is stable. Capacity is judged at the exact moment the contract is made. The third category is people disqualified by law. They may be major and mentally fit, but certain legal rules restrict them. Insolvent persons cannot deal with their own property because the insolvency court controls it. Foreign sovereigns and enemy aliens have limited enforceability of contracts in India. Even companies face restrictions. A company exists only for the purposes written in its Memorandum of Association. So if a transport company signs an agreement to open a casino, that contract is void as it is beyond its legal power. This rule prevents misuse of authority and protects the interests of the public and shareholders. Capacity to contract is a protective shield. If there were no such rule, minors could be trapped into lifelong debts. Alcoholics could be manipulated into signing away their assets. People with mental disabilities could be cheated without any consequence. The law ensures fair dealing and prevents exploitation by clearly declaring who is legally allowed to make decisions that create binding consequences. So remember this 3-step test. Before entering into any agreement, ask yourself, is the person above 18? Is the person mentally capable right now? Is there any law stopping this person from signing? If the answer is yes to all three, then the person is competent to contract and the agreement becomes enforceable.